Okay, so good morning, everyone, and thank you for being with us on a Friday morning after the gala dinner. Today, Anna Maria and I will share a few thoughts on the latest antitrust hot topics for in-house counsels, but probably not only for in-house counsels. We will try and touch upon both on the behavioral side, the FDI and merger control, trying to stick to our 45 minutes and leaving a bit of room for questions if you like. Starting from the behavioral side, and please, let's go to the next one. Okay. We thought we would share a few thoughts mainly on two issues. First is the labor markets. Second, sustainability. And then a few other thoughts on the trends and what the European Commission is focusing on. Let's start from the labor markets. Yesterday, we also had an interesting session on that. Last year, when I was speaking at this very conference, I gave a few statistics on where things standed at the time in this respect. And I noticed that both from an EU angle and a US angle, 2020 was a bit of the magic year, the turning point, because in the US, since 2020, basically we assisted to a stream of criminal cases being brought by the DOJ, mostly focusing on no poach, but also targeting wage fixing, or even both in the same case. With the focus on healthcare, but also other sectors, such as, for instance, the aerospace sector. Now, this strong focus by the DOJ is continuing. However, the DOJ is facing a bit of difficulties, it seems, when it comes to the outcome of these criminal cases in front of the court, because so far it has experienced the mostly losses in court. We shall see what happens, of course, next. With regard to the situation in the European Union, last year I noticed that there was, again, a stream of cases which had been brought mainly at national competition authority level. And there were two different phases, if you like. A first one from mid-2010, so say 2015, 2016, until 2020, where national competition authorities in Europe started targeting no poach, wage fixing cases in the context of broader cartel cases, though. And then since 2020, essentially targeting these conducts on a standalone basis. So we had a number of cases in Lithuania, the Netherlands, Poland, Greece, Portugal, among others. And this has continued. Recent examples from second half of 23 and first half of 24 include, for instance, the French authority now having sent a statement of objection for an alleged no poach agreement in the IT sector. The Slovak authority having opened an investigation against the Slovak Association of Undertakings for a code of ethics that apparently is suspected to contain no poach provisions. And also, I mentioned a number of guidelines, reports, and statements published by national authorities. So what's new? What is new, the main news in my view, is that the European Commission has now taken some interests in this market, because recently the European Commission has opened an investigation in the food delivery sector for alleged no poach agreement just a few months ago. And this marks the first investigation on no-poach agreements and more generally in the labor markets area by the European Commission, even though this case is not a self-standing case. It's in the context of a broader 101 case, but still it's indicative of the approach taken by the European Commission. And also, interestingly, in May this year, the Commission has published its policy brief on antitrust in labor markets, which is an interesting piece of work. Of course, it's only a policy brief. It's a relatively short document. It's 6 or 7 pages or so, but it's pretty dense. And the Commission is taking relatively straightforward views, if you like, in this brief, because it states explicitly that wage fixing and no-poach will, in most cases, be considered as by object infringement and are unlikely to meet the requirements to qualify as ancillary restraints, and are unlikely to meet the requirements for exemption under 1013. The theory of harm by the European Commission seems to rely in this respect on traditional rules, so wage fixing being compared to price fixing under 101(1)(a), no-poach being compared to supply market sharing, 101(1)(c), so essentially akin to buyers' cartels, and therefore, in the eyes of the European Commission, likely to be considered as restrictions by object. This is the European Commission had already taken similar views in the past. As you know, in the revised horizontal guidelines last year, basically the Commission included agreements to fix wages in the basket, in the category of buyer cartels. But even earlier than that, in the guidelines of the application of the European competition law to collective agreements regarding the working conditions of solo employed professionals, even there the Commission had clarified that agreements between sports club not to hire the respective players is considered likely to infringe 101 by object. Now, clearly one of the critics or one of the thoughts even before the publication of the policy brief was, all right, but these sort of agreements, labor market agreements, mainly affect workers, right? So where is consumer harm? Consumer harm, if any, is only indirect, if you like. And in the policy brief, the European Commission notes that wage fixing and no-poach are not only detrimental to employees, of course, but have also the side effect of reducing output and increasing downstream prices, especially for wage fixing, or stifling innovation, especially for no-poach, to the detriment of consumers. Of course, this remains to be seen, remains to be tested in practice and probably even before the courts. The Commission has also clarified that these agreements, these arrangements will be examined based on their impact on the labor market in question, so regardless of whether the companies are competitors among each other. So essentially competition here is for talent, okay? We heard yesterday Professor Ackman mentioning an active approach taken also by the CMA in this respect. So the CMA has set a new microeconomics unit recently, which published a report on labor market concentration, as was mentioned yesterday. The CMA has launched its own probes recently, since 2022, on labor markets. It is active in that respect. It seems that in the eyes of the CMA, on a slightly different front, non-compete clauses are deemed to generally fall outside the scope of competition law. So non-compete clause is, of course, something different. But this brings me to the US, because when it comes to non-compete clauses between employees and the employers, You know that the FTC has taken in the past a pretty aggressive stance in that respect, and in September 2024, this year, so just very recently, a new FTC rule should have come into effect, which should have had the effect of invalidating all existing non-compete agreements and prohibiting new ones, with a few exceptions and with a very broad definition of non-compete clauses. But however, there have been legal challenges, and these have blocked the rule so far. And the decision, the judicial decision rendered in Texas this summer is currently appealable, so we should see what the further developments will be. Moving to sustainability. Sustainability is also a hot topic. It's a hot topic not only in Europe, it's a hot topic around the world. We've tried to summarize in this slide, what the views around the world are. Not entirely the same views around the world, focusing on what is happening in the EU. In the EU, both the European Commission and a number of national competition authorities have recently provided helpful guidance on the competitive assessment of sustainability agreements. The revised horizontal guidelines of the Commission devote, as we all know, an entire chapter to sustainability agreements. And I have to say, the guidance provided by the European Commission provide helpful guidance, provide clarity to a large extent, but sometimes they may prove not to be entirely straightforward when it comes to being applied in practice to complex cases. So for instance, when it comes to assessing the pass-on to consumers of the collective benefits, the collective benefits being those benefits which occur irrespective of the consumer's individual appreciation of the benefit, and accrue to a wider section of society than only the consumers in the relevant market. And the EU guidelines require in this situation that, so also when it comes to collective benefits, that the consumers in the relevant market receive a fair share of the benefits, which, we can discuss in principle, and it is also maybe not, as I was saying, not relatively straightforward to prove as a matter of fact. So other authorities at national level in Europe also have provided guidance, as I was saying. The Dutch authority has been very active in this respect. It seemed to have views not entirely aligned to those of the European Commission, especially before the European Commission adopted the revised guidelines. After that, the Dutch authority sort of aligned itself to what the European Commission is now saying, its horizontal guidelines, with a few notable exemptions. So for instance, when it comes to environmental damage agreements, so those agreements that contribute to prevent environmental damage, so the typical situation where collective benefits come into light, the Dutch authority has clarified that they will not generally pursue this sort of agreement if it is plausible that the environmental benefits will outweigh the potential competitive disadvantage. And again, this is a situation where the environmental benefits by definition extend to a wider group of society than the consumers in the relevant market. A similar position has been taken by the CMA on climate change agreements. So those agreements which are primarily aimed at reducing greenhouse gas emissions. The CMA has acknowledged essentially that this condition, the exemption, can be satisfied by taking into account the totality of the climate change benefits to all UK consumers. Again, not focusing only on the consumers in the relevant market. But there have been also guidelines in terms of process, and I think this is particularly important. The French Competition Authority, for instance, in May this year, has published a notice in order to provide informal guidance to undertakings on sustainability issues, but in order to explain how to approach the French authority in order to informally discuss. So these are not guidelines providing, guidelines in terms of substance, but in terms of process. And this is very welcome, an initiative, I would say. Probably the French authority so far has been the only one going in such detail, and we shall see whether other authorities will follow path. We have carried out a survey at the end of last year. Essentially, we've commissioned a survey that has involved 500 sustainability professionals around Europe and the world in order to check where things stand in this respect, what the perception is in the community, and comparing those views to those that we checked back in 2020, where we carried out a similar survey so that we could compare the results. And basically, this survey shows, first of all, that the absolute majority, 82% of sustainability professional thinks that it is important to collaborate with competitors in order to pursue sustainability goals. Take a look at the motivation. I'm not going through all of the statistics, of course, but the motivation is also interesting. And of special interest to me is the increase in those that believe that customers are unwilling to assume additional costs for sustainable products and services unless these costs are industry-wide. And also an increase of the desire to be seen, to be working with others. That basically shows the importance for companies of demonstrating to their customers that they are committed to actively improving their sustainability credentials. Let's move to the next slide, please. Again, a few other statistics here, just to provide a few more bites on the results of the survey. You can see that around 60% of sustainability professionals would seek guidance by the authorities. So this suggests clearly that there is a number of businesses which are prepared to bring forward and discuss informally with the authority test cases, even though this means that 40% don't yet have that sort of confidence. And this is the reason why I was referring earlier to the initiatives, some of those from the French authority, which are very welcome, because these proactive models are maybe of inspirations for other authorities. I'll only mention a couple of other statistics, and this is the good news, because 80% of the professionals are willing, following publication of the guidelines by the European Commission and other guidelines, are willing to resurrect previously risky projects, and 72% are feeling confident in their understanding of what should be done or should not be done. And maybe I'll go back one slide. There is another statistic that I would like to highlight. 56% of the interviewees reported examples of sustainability projects that were not pursued because the antitrust risk was too high, meaning the only reason why the project was not pursued was antitrust risk. And 60% reported that competition law had played a role in them not pursuing the project. So it was one of the reasons. So these are interesting statistics, I think, and I believe the trend is the right one. An open dialogue in this respect with the authority is crucial. Moving very quickly to the macro trends at the EU level. So focusing here on what is happening in Brussels, European Commission mainly, a brief snapshot. Leniency applications continue to be an important cartel detection source. Leniency applications were declining in the past, but we are now seeing an uptick since 2020, 2021. And we are also seeing the Commission and other authorities relying on other detection measures more, though, which in turn probably fuels the leniency application again in turn. However, this has not yet trickled down to fining decisions, because if you look at the fining decisions in the period 2021-2023, it's clear that most of the decisions are still derived from leniency applicants. In terms of the areas of interest, there is a particular focus on the functioning of the single market. We've heard, of course, a couple of days ago, Enrico Letta also in that respect. And this can be already seen in cases in the consumers sector with a focus on vertical agreements, cross-border trade restriction, the Mondelez case, for instance. And we expect that this might extend to other sectors as well. Whistleblowing, that is working, apparently. The Commission has reported in April this year that they are now receiving around 200 leads per year through the whistleblower tool, with an improvement not only in the number, but also in the quality of the submissions that are received. Closing my remarks on foreign investment control. Thank you. Foreign investment control. This is something that should be in the radars of in-house counsels as well. It's now more than 3 years that the EU screening regulation has come into force, since October 2020. And at the time, there were only 15 member states that had some sort of foreign investment legislation in place. To date, there are only 5 member states that do not have such FDI legislation in place. And these are Bulgaria, Cyprus, Croatia, Greece, and Ireland. And actually, Ireland will soon join the club as well, it seems, because it has recently enacted new legislation on the matter, which, however, does not appear to be into force yet. Very quickly here, what is likely to attract attention? Clearly, foreign investment regimes focus on different sectors, on different industries. There are differences in national legislation, clearly, but there are some common themes which are emerging pretty clearly. And prohibition decisions, as well as decisions with prescriptions, are no longer limited to date to the core typical sensitive activities, military, for instance. On the contrary, there are a number of sectors which are under the spot, such as, high tech and others. Government contracts, of course, are of interest very often, especially where these contracts give companies access to sensitive information. Critical infrastructure, which ranges from typical physical infrastructure, transport, airports, docks, and the likes, to healthcare, insurance, energy, and telecommunications, and others, but also AI, advanced technologies, data processing, data storage, especially where there is access to large amount of information or even more sensitive information. I'm closing my remarks in this respect with a few thoughts on so what in terms of practical implications for foreign investment risk assessment. FDI processes are, sometimes a bit less predictable than what we are used to see in the merger control space. These are sometimes politically driven processes. These are sometimes processes that are less transparent than the typical merger control process. Less predictable also in terms of commitments that or remedies that might be requested or imposed by the authorities, and even processes that could require time. In terms of process, it is sometimes difficult to understand the actual concerns. There might be, confidentiality reasons for that or other reasons. There might be limited scope to actually negotiate the commitments with the authorities. So again, in terms of a practical advice, just very quickly, 2 or 3 points. First, FDI should be considered at the early stage of the process, exactly in the same way as anyone would do in a merger control scenario, including in terms of merger control, FDI multi-jurisdictional assessment. Second, it is very important to manage the CPs, the condition precedents, properly at contractual level in order to avoid surprises at a later stage. And third and last, keep in mind that not only the typical M&A deal can be caught by foreign investment rules, but also less obvious transactions, such as, for instance, intra-group restructurings, or even, the relocation of the registered office abroad, just to give you an example. And there might be much more amenities in this respect, but there is more, especially on the merger control front as well. So I'll leave the floor to Anna Maria in that respect.
Thanks, everyone. So, we just heard FDI. We will tackle merger control in terms of what we see as happening right now. We don't have anything on FSR. There's been a session in the festival on that. Of course, if you think about transactional, what it is that you have to advise in a transactional context, it's really FDI, merger control, and then FSR if the target is particularly big in Europe. So I think in terms of trends, what do we see? Intervention rates are increasing. I know I'm probably stating the obvious, but there is a big interest also because of geopolitical situation right now to everything that happens around merger control. We heard it yesterday morning, the presentation of the Lear study. There is a feeling that there have been too much consolidation in Europe and elsewhere, which also has led to higher prices, less choices to consumers, which also means there is a lot of pressure on competition regulators to really go deep. And we see that going deep also in matters that probably 10 years ago would have not had that level of attention, which of course translates in needing to do much more work to get it over the line. In terms of connectivity, the global cooperation and global enforcement has been there, has of course been established, but there have been new dynamics. The first one being the CMA. So with the UK exit from the EU, we have another big regulator on the ground that has its own voice, which is the CMA, and which has proven at times not to have the same voice as Europe, which I don't need to tell you what it means for a company which is doing a global transaction if one regulator in the UK tells you yes and the rest of Europe says no. So that entails that there is a lot of need to speak and speak early and kind of put all counsel on the same page to make sure that there is a strategy to how to tackle regulator across the globes. Investigations are burdensome. I mean, I think the trends really is just continuing. We see more and more requests of internal documents at a very early stage. And I think that fits a bit with the point one. You know, the regulators really want to get to a point where they can tick off every potential possible concerns on any hypothetical markets. And that, of course, means that they want to really go deep, a level down, and that ask companies for a lot of, particularly internal documents, speaking with employees. I mean, of course, if you think about the US process, you know, it's very much a dialogue with relevant employees. Again, all of that, you know, trickles down in the need to be prepared and the need to be, as a company, ready to tackle such a process. Internal documents, as I just said, continues to be a key focus. What it means, in-house counsel, please, please, please train your business people as to how to write. No, I'm not saying they should not write what is not true. But, you know, sometimes when you want to sell a deal to your board, what they write is simply, you know, this is fantastic, this is going to be the deal of the year. And I mean, you know, probably it is for them, but of course that means we will have a lot of work to do to be able to get down and understand and explain to the regulator why these words have been used. But also, more often than not, the words are just adjective used to sell a deal rather than being really the reality behind it. So I think, you know, we see a lot of training being run, but also kind of consciousness around how things are written. Remedies are becoming tougher and complex. I would like to link it to what Lucio was explaining on FDI. The fact that we have all these parallel streams, FDI and merger control, means that you might find yourself more often than not having to negotiate a remedy with an antitrust regulator and have to think how that fits with the commitment that the FDI regime might be asking you to do. So we are seeing at times contrasting requests. You know, a ministry in a state asks you to commit to remain in the member states for a number of years, not to dismiss plans, not to dismiss employees. A competition regulator might be asking you to divest that business in order to get clearance. So again, what does that mean? You need to start early and putting all this process on the slides and really think holistically, a step back, what might come from the different processes to me. The last point is, I think, the good news. I mean, you have seen the EU issued a simplification package, which also means that we see super simplified transaction be notified to Brussels, getting cleared very, very quickly on a form which is honestly a tick-the-box exercise with few definitions, which is great. Flip side, of course, substantive deals, you know, major transaction takes longer and longer. And wanted to give you a bit of indication of timing. So we looked a bit at stats. So this is EU. Look at the super simplified. We are talking about less than a month to get clearance, which is fantastic for business. Think about all the bolt-ons that financial sponsors do. I mean, that's a way to get through. And you see the stats mounts, but look at phase 2. I mean, we're talking about 16 months, of which almost half of it is pre-notification. And pre-notification is becoming longer and longer. I mean, we have seen that process probably in Brussels and also in some national competition authorities. The EU in its simplification package has, of course, kept a very tight phase 1 review period, 25 working days, 35 if we get it with remedies, which understandably is too short to get feedback from the market, too short to get really them comfortable. Again, think about the point about they want to really tick the boxes on every possible market. And so pre-notification, what we see is getting longer and longer. And you see it also on this phase 1 unconditional approval. So we are talking about deals that get cleared in phase 1 with no commitments. The average is almost 6 months. Why we looked at this? Because we're always asked how long it's going to take. I mean, that's the first question we get asked from a client doing a deal. And I think you probably, as an in-house, you also get asked the same question, you know, how long? I think the message is, if you are ready, and if you're ready to tackle pre-notification well, it's going to take a good point of time, but I think then I think there is more this certainty that phase 1 is going to go through smoothly if you've done a good job in pre-notification. But I think we also need to realize that if the transaction is complex, and if you are thinking that a phase 2 is possible, or also a phase 1 with remedies, you're looking at almost 10 months of work for a phase one with commitments. So that's quite long for a transaction as compared to a few years ago. Just one reflection on after Illumina Grail. I mean, if you are in Brussels like I am, the Commission losing on Illumina Grail was a big dismay. I'm just saying I had a call the same day on another matter with the merger unit, and the faces were really down because this was something important for the Commission in terms of attracting jurisdiction. Just to recap, I mean, Article 22 of the EUMR, which was called the Dutch clause, was introduced to tackle those jurisdictions that at the time of the EUMR did not have, these member states did not have merger control like the Netherlands. The Commission issued a guidance a few years ago saying, inviting member states to stand up transactions where they didn't meet EU threshold, but where, they thought there could be concerns. And what had happened in Illumina Grail is, we are in a healthcare space. Grail didn't have turnover in Europe. And because of perceived substantive concerns, the case was referred up by a number of European member states. So the Commission took jurisdiction, reviewed the transaction, prohibited the transaction. So went through all the steps to including courts. And Illumina appealed on a number of grounds. The main one saying, you Commission cannot take jurisdiction where on a referral when the member state itself does not have jurisdiction under their own domestic rules. A few weeks ago, the European Court of Justice confirmed Illumina's view, which also meant, the Commission had to close down all this investigation and said, okay, we didn't have jurisdiction. So, Illumina in the meanwhile had been fined for closing the transaction, had been filed for gun jumping. So there were a number of other decisions. But what had happened in the aftermath of this case, and I should say there has been other Article 22 cases that the Commission reviewed, a number of member states, which I think is very interesting, had already tackled this issue by introducing in their own regime call-in powers. So the ability to call in transactions, even if they don't meet, I would say, the traditional jurisdictional thresholds which are provided by the law. Why is that? I mean, again, it goes back to the concern that there is a lot of consolidation and that sometimes there are transactions that fly below the radar. And some sector, like tech or healthcare, are particularly of attention. Think about you buy a company that is developing what is expected to be a very successful pipeline compound, but of course the company has no turnover because it's still in development, so there is no thresholds being met. What the regulator are saying, yes, but you are paying millions and millions for that compound, so there must be something behind it. So here you have a bit of a map to see, what are the countries that have introduced this power. Italy is being one of them. We heard Commissioner Jossa 2 days ago referring to those cases. There are a number of cases where the authority has called in matters, but also cases where companies that voluntarily, on a voluntary basis, reported to the authority. I mean, knowing about these powers and wanting to have, I would say, legal certainty in terms of timeline to closing, they went in and said, look, this is what we're looking at. So I think this is something to keep an eye on. The expectation is that the other jurisdiction might want to introduce this legislation after this, knowing that the Commission now is in a phase where, unless they change the EUMR, they cannot really do that much. So I would say it's an area to keep on under watch. In terms of a bit of a summary where we are, I mean, here it's, merger development for those who does transactional work. You see more and more investigations. There is, more and more attention, for instance, around the notion of buyers. When you have remedies, who's going to buy this business? Is this company really ready to run the business as it was before? Which, of course, also triggers a bit of attention on interlocking directorates. So there is, starting a bit with the US, there is this trend also, when you notify, oh yes, you're a financial sponsor, you tell me you have nothing, but I see you have a lot of 15%, 20% investments in a lot of, related industry. Can you tell me a bit what you're doing? And that goes with the minority investments. I mean, I think, to be fair, we are all watching and see what happens. We have a new commissioner coming in. She has been given a very clear mission, and one of the pieces is around how to use merger control rules to improve competitiveness of Europe. I tell you, Brussels is divided. If you speak to DG Comp, they will tell you there's no way that merger control needs to change, because we should continue to do what we have been doing. Of course, there is politics, and there is a Europe that feels very exposed. So we will have to see. There is, I think there is going to be very interesting developments. But let's see when the first big transaction come in, and she will look at it. So I think just in key takeaways, I think we've tackled most of them. It's really just, I would say, get ready. The timeline, be realistic when you give in timeline to your business colleagues. Think about, and be ready also means, when you prepare internal documents, think through, get them short to know what they're doing. Be ready for deep investigation. The reason why I mentioned that is that a transaction is in itself a disruption to the business. I mean, it's disruptive. You have all these people who have been asked. But given the level of information that we are asked to provide, disruption is a very high level of disruption. So we see, for instance, how effective it is to have a couple of individuals that are fully dedicated to support, rather than having, a scattered number of individuals that runs the business and at the same time have to answer to all our thousands of RFIs in parallel to their daily job. But just to say, I think it's to be ready. Do not simply say, this is not just for lawyers. That's the point. It's really the business is essential in terms of support. I think that was really we wanted to share. I mean, there is a lot to be said, but I think there is also a lot to be seen with the new commissioner coming into her new job soon. So I'm just conscious of time, but wanted to see if there were any questions from the audience on anything we've tackled this morning. Sure.
Increased legal certainty from the company's perspective?
I think most people would say it has increased legal certainty. I mean, I cannot tell you how difficult it was to draft a CP in a contract to envisage the possibility of a member state sending you up to Brussels and Brussels picking up jurisdiction. So I think it has generally increased legal certainty, but still, that's why we focus on, there are a number of member states that have calling powers. So I think depending on what are the activities of the target, we should focus on, we should not lose track of that.
In most cases, as Anna Maria was saying, you'll need to take an holistic view, right? Because if you're a seller, you'll always ask for an hell or high water. So it's a matter of negotiating power. It's the intricacies and the inconsistencies between the two different systems, which is very difficult to tackle sometimes, in my experience.
Maybe following up in part on Illumina Grail. So there are two ways to go about mergers below the thresholds. There is Illumina Grail under Article 22 and the merger regulation, but there is also 102 and Towercast. And so basically, the problem, I must have a big problem with Towercast, because Towercast basically is 102, which means that you can go to whatever judge, one, down in Italy, another one in what would be a big village in Belgium, and then you can go to other judges if you want. And that obviously, if you want to complain about a merger, if you want to launch the negotiations, because that's also the thing, you can, file a complaint and then basically, renegotiate. So if you are a big customer of whatever two firms that are merging, you have been buying from one and the other, and you say, by them merging, I don't have the choice that I had before, and which means that you can quite quickly go and launch a negotiation, which means that basically, and you can also withdraw, because in part, competition authorities would lose their monopoly in terms of merger control, because you can go directly to the courts and negotiate whatever outcome you want and then withdraw. And that puts, I think, a lot of uncertainty. And so basically, the kind of mechanism that you have under 102 means that you can be much more difficult for a merger, especially if you take the timeline into account, because the timeline you have shown for phase 2 seems like a dream in many jurisdictions for 102. So anyway, what do you think about that?
Yeah, look, I mean, it remains, I think and Belgian authority has been one of the first that acted on Towercast. So, look, I mean, the reality that remains a world where big transactions will find a lot of obstacles to go through. I think Article 22 and Illumina Grail decision is a piece of the legal certainty, is not all of it. Of course, on Towercast, I mean, you need to go to court, yes, but I mean, that courts take also a lot of time. So I think it's just leaving a lot of avenues to complainants to come in. I would say on the positive side, though, that we see regulators, I mean, if I look at Brussels and Commission, be very thorough. I mean, they do not believe really at everything that complainant says, and they are quite well aware that there are strategies and that there are companies very well known for using regulatory means in order to achieve commercial objectives. I mean, they're known to the market now. So, look, it leaves a very interesting question to us as advisors and those who are in the field. But I think it all fits with this idea of we need to make sure we're making the right decision because the markets are too concentrated. And that's where we see a lot of regulators coming from. So I agree with you. It's not that it's clean, but I think Illumina Grail and the Article 22 approach was a very challenging. I mean, to be honest, it was hard also to advise clients because you never really know. And we have seen it used. I mean, Illumina Grail was, from a substantive point of view, a very problematic transaction. It was not just, that the FTC, we shouldn't forget about it, was about to prohibit it as well. So there was a substance. But there have been other, you would get constant RFIs from the Commission on a random transaction. Can you please provide all these documents? So what I would say is that it's not finished. The CMA still has, an information merger unit that sends you RFIs constantly. So, there are other regulators. I think it's very much to also what Lucio was saying, is to be able to have a holistic view and not lose track of what might come your way and be ready to tackle it. But it's just the ultimate message is that if the transaction is a big transaction with a lot of substantive concern, it's going to take much longer to get through the process.
And also, I agree that Towercasts add a layer of complexity indeed. But on top of what Anna Maria said, just a couple of thoughts. The Towercast issue was already there since Towercast, so independently of Article 22 and where it ended up. But and second, I see your point about the multitude of possible judges around Europe on whose table this could end up to, and maybe the fact that you may not expect a sophisticated analysis as much as the one you would have had if you ended up in Brussels. I see that point. In practice, so far, it has been used, in a very limited number of cases. Yes, Belgium was one, but so I would say in that respect, it's the use of Towercast has been, so far so good, I would say. Let's see what comes next.
Any other questions?
Yeah, thank you. Yes, thank you. A question about environmental agreements and Chapter 9 of the Communication on Horizontal Agreements of the Commission. The problem that we face, I think, in some jurisdictions is that, as you mentioned, you know, some national competition authorities like to use a broader approach when it comes to environmental agreements, and especially when it comes to the side effects in the markets. I remember that we discussed it a lot as national competition authorities with the Commission and with others, with other colleagues from national competition authorities about this particular problem on side effects, because the Dutch, the Greek, the French were very much for, you know, side effects analysis in Chapter 9, and the Commission didn't follow. Now, the problem that we now have, I think, and I would like to hear from you as well, is that we might have an application on 101(3) which is not uniform throughout the European Union. And that, to me, is problematic. It's problematic because at the end of the day, with this communication, and in particular with Chapter 9 that they added, we didn't solve the problem when it comes to environmental agreements. Thank you.
I agree. I agree. I mean, I hope we won't be assisting to some sort of forum shopping, you know, in order to check what's the right authority to go and discuss these sorts of issues. I mean, it is particularly important, of course, the role of the European Commission is particularly important, of course, because generally sustainability issues are rarely limited at a local, national level, right? So, my personal view is that it would be great if, as a matter of fact, at least when it comes to the actual implementation of the rules, first, the European Commission was, as it seems it is to a certain extent, open to informal discussing with the parties, so that, you know, and second, so that there could be an actual factual leeway or flexibility in the actual application of those rules. But I agree with you that the horizontal guidelines are a first step, and there could be some room for improvement going forward. Any other questions? If not, thank you very much for your time.